So where are we on this case?
I don't know if the two of you had discussions on this issue.
Is that okay with you? Oh, good, because you don't have a choice.
Court does call the case of People versus John Johnson.
Good morning. Is this the public defender, Lauren Perny, on behalf of Mr. Johnson? Mr. Johnson, can you state your name for the record, please?
John Johnson.
Your Honor, today is the date and time scheduled for sentencing. I did speak with Mr. Johnson. I did review probation's recommendation. We do ask that you adopt probation's recommendation. He additionally did complete his assessment yesterday. It was delayed, but he did complete it, and I did get a report from Von Schwartz.
Teresa Claire on behalf of probation. Your Honor, I can confirm that Mr. Johnson did complete the assessment with Von Schwartz yesterday. I got a copy of that emailed to me last night. I do have some concerns about Mr. Johnson's honesty when he was answering the questions at Von Schwartz, given the report that I breezed through. I haven't had a chance to look at thoroughly to give a recommendation. At this point, Your Honor, I guess I would ask that Mr. Johnson be remanded and that we adjourn sentencing to February 28th. That would give me a chance to take a look at that, and it would also address his bond violations. There's been continued use of drinking while on the sober link. The court did get that report when the bench warrant was issued, so the case is currently on bench warrant status as it is.
Anything you want to say to that particular recommendation?
Your Honor, Mr. Johnson and I did have multiple conversations about the report. Frankly, he admits in part to drinking and denies in part in drinking.
Denies which part of drinking?
He denies the, Your Honor, if I may get my computer back to the exact page. He admits that he drank on the first
The November, December dates?
the February 1st date.
So he admits to those.
He admits to that date.
That's it?
He says the other date he did not consume alcohol.
Well, hold on. Because on February 1st, he's admitting to those.
Right.
There's then blows on February 2nd. He's not admitting to those.
The 7th.
The report that I sent you. He's not admitting to the 2nd or the 7th. He says that he did not consume alcohol. The only time he says he consumed alcohol was on the 1st. And again, it's the explanation in the report. I was hoping that.
Well, the explanation in the report is relevant to the court.
Right. That's why he says he consumed alcohol that day. He says he did not consume.
So hold on, just so that I'm clear on this. He's here on operating with blood alcohol, with a high blood alcohol content. I give him the opportunity, he's released on a sober link, violates the sober link, right?
Yes.
Gets mad and then drinks.
He says that he was mad because he did not drink alcohol that day. He drank Robitussin, but then did have
Which date he drank Robitussin?
Says on the 26th. I'm sorry, on the 25th, there's a positive blow. The first one being a 0.028. Told the agent that he drank cough syrup. And then on the first, he also had a positive blow. And he did admit that he consumed alcohol that day.
He's gonna have to start being honest. That's not a Robitussin blow at all.
That's why I don't mean to interrupt. I'm here I'll take full responsibility for my actions, Your Honor.
Well, you gotta start being honest.
I'm very.
Because your attorney's up here telling me that it was a Robitussin blow. You get mad because I issue a bench warrant because there's alcohol showing up in your system, which, oh, by the way, you're not supposed to have anything with alcohol in any respect, whether it be Robitussin, whether it be beer. Doesn't really matter.
Yeah, absolutely.
But I'm looking at the numbers. There's no way you consume that much Robitussin and then blew into that machine. It didn't happen.
No, that's why I'm here.
Then I issue the bench warrant. You get mad and decide to have a beer.
I did, Your Honor, and I take full responsibility for my actions. I'd like to apologize for the time.
Then I've got blows on the 2nd, which you're not admitting to. I got blows February 7th, 2024. You're not admitting to that. I got blows on the 8th, which, well, on the 8th, you didn't retest. Then on the 9th, I've got blows, which you're standing here before the court not admitting.
I'll admit to all of them, Your Honor. I'm not sitting here trying to blow smoke up the court. I'm not. I'm here to take responsibility.
So you can do whatever you want to do, but I'm just trying to figure out what you're admitting to.
I'll take. full
Because,
responsibility
look,
for all-
young man, listen. You want to play a game with me, I'm probably not the judge you want to do that with. So you should probably talk to your attorney. Do you have the full report, Ms. Farney?
I just got from Ms. Pilara the 9th and the 10th where he did not retest.
The 9th and the 10th.
I'm sorry, the 9th, there was a positive test as well. And then it goes from the 9th into
The 10th where he just didn't retest. And then on the 7th, you see that one, February 7th?
Right, yes, I have that report, yep.
And on the 2nd, there's additional flows on the 2nd of February where alcohol comes back.
Right,
Then on the 7th, where alcohol is picked up, and then on the 9th. So apparently he was mad about the bench warrant for a long time.
I'll plead guilty to all of them, Your Honor. I'm not trying to play games with you.
I didn't hear you.
So I will plead guilty to all of them, Your Honor. I'm not trying to.
Did you do it?
Yes, sir.
Then why'd you tell your attorney you're only admitting to one? You knew you had been drinking. You also know it wasn't Robitussin. You know something? You're just gonna have to be honest.
Yes,
At some point,
yes, Your Honor.
what's your next sentence in there?
Next is the 28th.
That's in a one.
Yes.
Adjourn defendant sentencing in this matter February 28, 2024 at 1 p.m. Defendant is remanded to the Washington County Jail. He's to be held without bond pending sentencing. Defendant remanded. That's it till 10 o'clock. That's a wonderful way to end that.
So where are we on this?
I don't know if the two of you had discussions on this issue.
Is that okay with you? Oh, good, because you don't have a choice.
No bond conditions. Like you say.
Yes, sir. My mayor, are you? This is Robert. Tell me, what is this?
It's a bench warrant from Tarrant County. They're asking for him
Did you know that?
I had known that, but
Make
it
it-
surprised me because I knew that
All
was
right,
coming.
make a copy of this, please, and 2 copies for the defendant. There's a bench warrant.
Yes, sir.
For Tarrant County.
Yeah. So that's what we were wanting to do, is the Tarrant County taken care of first, and whatever happens there will resolve these cases. Because
Yeah, but I was,
oh, I know, because we had them, and I understand the court's position.
are these all 3rd-degree felonies?
Yes, sir. Okay.
And
I believe, right, son? Yes. Speak out of time.
we call 23-41491 through 41500, which are going to be 10 cases. Yeah, 10 cases in numerical sequence, all alleging in the indictments, 3rd-degree felonies of illegal possession of child pornography. And you were Robert Pascal Taylor?
Yes, sir.
Are these all the same day, on or about the same day?
Yes, sir.
Yes. Thank you. Yeah. Was this one you gave me, or is this one you had?
I gave that to you, Judge. I have
You
a
have-
copy of myself.
There's 2, one for you. The client, there's a probable cause affidavit here that was filed in these cases. Hundreds of images of child abuse. 10 were selected for individual indictment purposes. Have you seen these? Have you
The-
looked at this?
The images?
Yes.
Yes, I know what they
What
look like.
about, what is the age of the child?
Judge, this is
Apparently,
the apparent age of the child in most of the videos is probably about 13, 12. It's his own daughter.
whose? This man's?
Or stepdaughter, something. The underlying complainant in those Fort Worth cases.
Okay,
Whoever,
let's not be coy with the court, Mr. Taylor. Is this alleging that the person, the child depicted, same child?
yes, sir.
Same child depicted is someone you know or related to in some way, shape or form?
I don't know. I don't get, I mean, I know what my charges are, but I never saw what the pictures were.
Have you shown him anything?
Did I show the pictures? You want to show the pictures right now?
Yeah,
Okay.
I want to quickly,
Judge, I don't have the pictures here, and they're not entitled to have them, a copy of them in discovery. They have to come to our office to view those.
Yeah, and he's in jail.
okay, this is just for the purposes of identifying who the child is. He says he doesn't know if there's something you have that can, I don't want the name, I just want to know what you contend, you have proof that shows the relationship of this person, that's all.
1 second, Judge. These 2 names right here.
This next roommate's kids, Your Honor.
Okay, these are
Alleged.
various children.
That's alleged victims in the case.
The victims
Yes.
were allegedly the defendant's former roommate's children,
Yeah.
children of the former roommate.
Yes.
Each of these allegations are, of course, despicable in nature because it shows the children, according to these probable cause affidavit, out of the hundreds of images of child abuse material, the 10 that were used in each of these indictments include the appearance of an adult's in the child's mouth, another similar image, adult male penis in the child's images of the male adult in these. Who, do we know who that is?
Judge, they've been connected back through through the Arlington Police Department's investigation and through Beaumont Police Department's investigation to be this individual, this defendant.
Okay, that's what you're contending is not only are the images showing child pornography that were in the possession in these indictments of the defendant, but you were contending that it's the defendant who is pictured as the adult in these acts.
Defendant's face can be seen in the surrounding areas of his room and in the environment that he lived in can be seen. And then also there were CAC interviews done of the two children and they both identified him.
There were two children.
Yes, sir.
More than the one. All right. The bonds are how much?
25,000 each for all 10 cases, and there are no bond conditions either. JP did these originally.
Judge, I honestly, I think
What's he saying?
I think that if the court is going to be willing to let the other court, the criminal district court number 2 in Tarrant County take him, that the ideal thing would be to revoke his bond so that he's accruing time here and have no bond.
Say that again.
He's not on bond here with us.
Right, he's not a lot.
Right. So
Just
remove his bond so
What
that
do
he's
you-
accruing time.
Okay, what are y'all wanting, state?
Judge, I think that the thing that we want is for him to be tried in Tarrant County for continuous sexual abuse of a young child, which is what they want him for.
Thus, how this court has seen enough that it's most disturbing, to say the least, and it is the type of conduct and the type of allegations which the law provides for some of the most punitive bond conditions and bond amounts. But what is it you're asking through the state and through prosecution that you want me to do? Because my impulse is to hearing what reading the probable cause affidavit, reading the indictments, and listening to what the contention is from the state, is my impulse is the magistrate certainly must not have been aware that the state was contending that the children pictured had a relationship to this man, and this man is believed to be the male whose sex organs are being inserted into the child's mouth, is painted there, and they're.
I wholeheartedly agree that the bond amounts here in your court are not adequate.
Okay, well, I didn't set them, and I certainly wouldn't have set them at that amount, knowing what they are, knowing what the circumstances are. So what are you asking the court to do here? What should we do? According to the state, and then I'll listen to what the defense says.
Either, Judge, what are they currently? 20, 25 each?
10, that's 250. But
I mean, honestly,
everybody knows what I think, what I've always stated about these types of cases. When a child is victimized in a sexual way, then child pornography has very high bonds. But if the images are being created by the actor who happens to be the defendant, and he is not only producing it, but he is the lead actor, male actor in this perverted video production, then it becomes more punitive.
Well, and Judge, I think that somewhere between 75,000 and 100,000 per case bond amount would be much more appropriate, given what we know about the case. And in addition, I think that if he is bench warranted to Tarrant County, I think from our perspective, we would want to do something that would ensure that there would be no circumstance where if something happened in Tarrant County, he would not be brought back here first.
Your Honor, our position is that if Tarrant County wants them, then obviously we can't stop that. If it's resolved in Tarrant County, if he's found guilty in Tarrant County, then what we can do here to him is nothing compared to what the minimum is
Talking
there.
about the bond here, that's all.
I know, I'm
What are you?
I'm leading up to that, Your Honor.
Yeah,
And then if he is found not guilty up there or it gets dismissed, then we can bring it back to try this. In the meantime, Your Honor, right now the bond said 25,000 each. That's $250,000. That, and I understand the court's position. If it was one charge, yes, $25,000 is not a lot for one charge of this, and I understand that. But we're talking about $250,000. So our position is that the bond should be lowered to maybe something in the range of 10 to 15,000, which is because of the amount, the overall amount. It's 10 cases. It's still $100,000, Your Honor, which is if it was one case would be well sufficient to hold it.
well, let's talk about, I know where you're coming from. Article 17.15 for the rules for setting amount of bond under the Texas Code of Criminal Procedure. That's our guiding light here. Number one, the nature of the offense and the circumstances under which the offense was committed are to be considered, including whether an offense involving violence as defined in 1703. But we all know inherently within the nature and the spirit of these rules, when we're talking about the circumstances of an offense, who thinks that the sexual abuse of a child is not of the most serious nature? Nobody does. We all do. We all think it is most serious. So the nature of the offense is extreme. Here, not only is the man possessing child pornography of two victims, but it's someone he knows. They're people he knew. And according to the states, he is the participant in the videos, the sex organs of the male being inserted into the child and mouths are his, according to the state. So the bonds, I agree, are not enough. And I'm sure the magistrate did not know some of these facts. So I am going to follow what the recommendation is from the state, $100,000 on each case.
Before you make this, I would like my chance for my client to speak, because I know he's wanted.
Go ahead.
Court quite a bit.
Yeah. Raise your right hand.
Chance to.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And Dennis, would you please tell the jury we're going to need about 10 more minutes, please, and thank them for their patience. Go ahead.
If you want something, Judge, or ask for anything.
Well, I know I've been accused of this. I know it's really a severe crime, but
You think?
I know.
No, what,
I mean, I just.
how severe would you say such a crime is?
Life-changing.
No, I'm not for whom, but certainly for the victims.
Sure.
But would you consider this one of the most horrific type of crimes when children's innocence are taken away by an adult in a fashion that is then played out by photographs that can be distributed where they will be victimized their whole lives? Would you say that's serious?
I would.
Okay, go ahead.
What I'm saying is I did not commit these crimes, and I know it's been stated against me. I also know I haven't gone to court there, but the judge there even lowered my bond from almost $1 million down to 80,000, allowed me to come home and take care of my mom while I was waiting this, with the condition of reporting to a bond probation officer once a month and a bond company once a week. But I haven't had any chance to fight this, to prepare a defense, to even, I don't even know how the stuff that's gone on again.
Sir, I just read to you what the rules are.
Yes, sir.
For setting bond. The presumption of innocence still is the standard.
Nobody needs to tell me about that. I wrote the leading article that's been published on that subject matter. Okay, so you're presumed innocent. I know that, but a grand jury says probable cause exists that you did it, that you illegally possessed this pornography. The state's contention is the evidence shows you're the participant in this, and you certainly were connected to the children. You knew them. They lived with someone in the household of a female companion.
Yes, sir.
Of the defendant. So they contend that not only are you illegally possessing this, but you were the one who manufactured and was the lead actor in this, in the role, as it is apparently the same person.
Yes, sir.
As the state states. But these rules for setting bond are the nature of the offense and the circumstances under which it was committed are to be considered. And the presumption of innocence, they know, the legislature knew about the presumption of innocence, and these rules are made for dealing with people before they have been convicted of the crime. But you're just not charged by a complaint. You were charged by a review of a grand jury that determined 9 or more people reviewed the evidence and state probable cause exists that you did it. So they're not just supposing, they're not just guessing. They're using probable cause in making their decisions. And that's why the rules are the way they are. Rules are here to be used before you have been convicted beyond a reasonable doubt. So the presumption of innocence is built into this, but it's built in for a good reason. So that the safety of the community is taken into account when the nature of the offense is so extreme that it is viewed that the defendant may be dangerous to others if released. And along with the statutory determination of rules for setting amount of bonds, case decisions have included aggravating factors of the charged offense can also be used in setting bonds. I don't speak for another magistrate, but I've been doing this for 40 years. And in the federal system, in the state system, and I know what the law states and I know what the court decision states. And this court has a hard time with its vast experience, even thinking of many cases, but few cases exist from my experience that have more serious aggravating factors than what's alleged in this indictment and what the state's position is in their investigation of your involvement with the production of this. And those are the basis for determining bonds. So don't preach to me that one magistrate's decision, whatever they may have used, I don't answer for them. I answer for me and the law. And so it's $100,000 on each bond, on each case. Plus, if you happen to make the bond, you will be confined at home. You must have a GPS device, and you will have no contact, absolutely no contact with any children. Were there any other, if he happens to post a bond, is there any other?
Would you want to limit his access to electronic devices, Judge, given the nature of the charges?
Well, one of the bond conditions is don't commit further crimes. That's always number one. There's
Pretty
a host
self-evident.
of bond conditions that are normal for everybody, but this would be specific in your case.
I think that is sufficient, Judge.
that is the decision of the court on these. So they're going to bring him back up to Tarrant County?
Yes, sir. I will reach out to that court and at least make a connection between their staff and your staff and
So has he been charged officially? by
yes, sir.
the
Yes.
government up there?
Yes.
They've got a
So there's a warrant for him?
Yes.
Like you were saying?
Yes, sir.
So,
And that case is
so,
pending up
see,
there.
that's another thing is, I'm not sure that we really needed this hearing because with a warrant,
He's gonna go up there.
he's not released. So I think maybe it would have been better to hold this hearing once the people up there decided whether they were going to release him and we had a hold on him. But nonetheless, we did it. And this, based upon what y'all find, if any additional information is learned, let me know and I can change my decisions for the defense or for the state's benefits. But everybody knows what I heard, and none of this is good. And my rulings are based upon the Code of Criminal Procedure.
yes, sir.
Okay, anything else? That's all. Thank you. Here is this stays with the case. Thank you. All right, let's get ready on this.